Do you want me to get started?
I'll go ahead and do it. Okay. I'd like to bring to order the afternoon committee meetings of the Bellingham City Council. The first committee is chaired by Councilor April Barker. It's our Justice Committee. April.
Thank you. I'm joined today with Pinky Vargas, should be here shortly, and Terry Bornman. We're here to discuss the role of the prosecutor and the municipal court and how a case moves through the court system. Should I hand it out to you, Peter?
Yeah, I think I'm the one to start out here.
Thank you.
So Peter Raffato, City Attorney's Office, and Ryan Anderson, lead prosecutor. We'll get into some details here in a minute, but I just wanted to start out again with a couple themes that I have sort of observed since I became the city attorney. And one of the themes, so a philosophy, an approach that was communicated to me, and this was in the context of when we're looking, and it's been a while, we've had a very stable group of prosecutors, but when we went to hire prosecutors, it was communicated that, the municipal court and the perspective of the prosecutor's office is that it is a rehabilitative court. And so that's one of the themes that we think about, for example, when we're going through a hiring process. And I think some of that theme is echoed in the ABA quotes that were provided to you in the memo, in terms of the prosecutor being a problem solver, having a community-wide perspective. And so I think that's some of the reason we had, along with the court, obviously, some diversion approaches, even, for quite a while, those have been in place. And the second theme, again, from the prosecutor's perspective, as communicated to me, is, the municipal court is a court that a lot of folks in the community, whether they be potential victims, witnesses, reporters of crime, or even defendants, more people than in other courts will come into contact with that court at some point, because it's not, the crimes aren't as serious. And so that's kind of a theme that is important, because we know that how our office interacts with people, regardless of who they are in the system, will take that experience and have a perspective from that experience. So that's just another theme. And so those are just two things I wanted to mention. And also just thank Ryan and the other prosecutors and the prosecutorial staff for being agile over the last couple of years and dealing with lots of different situations in terms of jail space and whatnot. But I wanted to mention that too. So with that, I'll turn it over to Ryan.
Good afternoon. My name is Ryan Anderson, lead prosecutor with the City Attorney's Office. I think I know most of you. So I've been in the prosecutor's office with the City Attorney for about 11 and a half years. So I've been there for quite a while. I pretty much know, I would say just about everything, but you never know everything. But I know quite a bit about the court and can answer most of the questions. So the ground I want to cover a little bit today, I'm going to divide into really three categories. One, we'll kind of talk generally about what the role of a prosecutor is, just really in big picture terms. Two, briefly to discuss some of the more common crimes that we have and what we see in municipal court. And then the last thing we'll do is cover kind of sort of how a case funnels its way through our office, and then kind of maybe cover, I think Lieutenant Ulmer was here a couple weeks ago and may have covered a few scenarios with you. So I'll kind of, with that, I'll cover those scenarios as well.
Okay. Ryan, before you continue, I just want to acknowledge that we have Judge Deborah Lev here, and I forgot the title of you. Court Administrator? Okay, Darlene Peterson. So you're welcome to join us if you'd like. Thank you. Go ahead.
Sure, certainly, yeah, and I'm sure they have something to say after. I've left some things for the court today. I'm not going to talk the whole time, trust me. So I hopefully only have about 20 minutes. So for me anyway. So let's talk about big picture. So when you think of the prosecutor's office, what you have to remember is that we're one party of a process, right? We are not the process alone. We represent the city in prosecution of the offense, but again, we're not the entirety of the process. There's the court, there's the defense attorney representing the defendant, and we all play different roles. We wear different hats at different times, and we all have unique interests. We don't all share the same interests necessarily. Now, we share the same interest in at least wanting to see the administration of justice occur, but when it comes to real specific interests and goals, we each play a different role and wear a different hat. There are a lot of guiding principles for a prosecutor, and as Peter, I think, put in the memo that you received, some some of the ideas in that ABA standards, and you can kind of get a good flavor of what I mean when I say that there's some real guiding principles for us. There's also ethical rules, rules of professional conduct, and in fact, there's very specific rules in the state of Washington that govern just prosecutors. Defense attorneys don't have the same rules. Judges have their own set of rules, but they specifically target what a prosecutor should be doing and how they should do their job, which is very different than every other attorney in our profession, whether it's defense attorneys or civil attorneys. And the backdrop of all of that, of course, is the principles of justice. But it's key to remember that there are differences between the way that I'm going to do my job and have to do my job and the way, for instance, a defense attorney does their job. And just by way of example, remember that, you know, the defense attorney represents the interest of the defendant, the stated interest of the defendant. What does the defendant want? What outcome are they looking for? What are they hoping for? They're not necessarily looking for, and this is not a criticism, they're not necessarily looking for, oh, this person needs treatment, let's work on treatment for them. If the defendant doesn't want that, then the defense attorney is working to not get that. If it's to expose weaknesses in a case or to hopefully see a victim not appear at trial so their client gets a better deal, that's what they should be doing. That is their stated purpose, their stated goal. That's not mine, right? I'm looking at the bigger picture. What is the victim input? What is the principles? You know, how can justice basically best be served in this situation? And potentially also, obviously, looking at what is maybe the best outcome for the defendant with the information that I have. So we have a very different, we're all on the same team to some degree, but we're not all necessarily have to be rowing in the same direction, right? Because these are all different parties wearing different hats, and it's important to remember that. And when I say that is, I don't represent the defendant. I don't represent their interests. I'm not there to do exactly what they want. I also don't represent the victim. As the city of Bellingham, we certainly are the conduit for the victim to access themselves and you know, get their opinions, their thoughts, their ideas, their concerns through the court case. That's really, you know, one of our roles, at least with the victim. But we don't represent the victim either. So it's just really, you can see the complexity of what we have to operate, which is we, to some degree, obviously we represent the city, but we're also looking at public safety. What are the public safety concerns that exist? Also looking at the defendant's interests. How are we upholding the defendant's rights and interests at the same time? How do we make this defendant whole if we can and if they're ready to engage and be made whole? How do we balance that with a victim who wants to see X, Y, and Z? Maybe realistic, maybe not realistic. How do we do that all within the constraints of also looking at the facts of the case that we have, and can we reach a resolution? And my point to saying this is if it sounds complex, it is, because we don't just have a stated interest. Defense attorney, I represent the defendant. What do they want? That's what I work for, right? We have to balance all of those interests in trying to find a solution to this problem. But, and by problem, I mean the criminal case, and seeing how do we stop this behavior going forward? How do we look at accountability? How do we look at rehabilitation? Now, when I say that also is I don't control the outcome of the case. I can incentivize certain outcomes of a case, but I don't actually make the decision. The defendant always makes the decision. I can offer a certain plea agreement or a diversion or an opportunity to go to mental health court or any of the other programs we can talk about. But ultimately, the defendant is the one who makes the decision. They decide, I'm going to take that offer. I'm going to enter into that program. I'm going to do this or I'm going to do that, or I'm going to fight it and go to trial, and I'm not going to do anything that you want me to do. Right? They make those decisions. So when I hear people say, well, you know, prosecutor's office, you guys should just make everybody do mental health court. Great. I can't do that. I can offer mental health court. I can incentivize someone who I think really needs that to do it. But if they don't want to do it or they refuse to do it, I do not have the ability to force them to do that. I don't have that ability. It's always the defendant choosing. They essentially choose their own fate to some degree, right? So we're balancing all of those interests, the fair process, victims' rights, community safety, hopefully getting the defendant sort of, you know, chartered in the right direction here. All of those things come into play as sort of the mindset of a prosecutor. So I know that's kind of a big picture, but that is all happening, right? So when we look at some of our more common crimes that we have in the city of Bellingham, I'll give you a few, but I'm going to use one as a specific example to talk about sort of the complexities that we have. DUIs are very common. And that can be a person's first offense DUI. That can go, you know, frankly, all the way to multiple priors. There's some levels at which it becomes a felony within a certain timeline, but we have people with 4, 5, 6, 7 prior DUIs over their lifetime. So we deal with people who are, you know, chronic DUI offenders. We deal with assaults, and those run the gamut from everything from minor, very, very minor incidents to very, very serious assaults that may even have some elements of a felony assault. There might be broken bones or other things, but for whatever reason, they are not charged in felony courts, they come to us. So we definitely see the spectrum on assaults. Disorderly conduct, obviously in the Bellingham Municipal Code, I think there's 5 different sections. We really only see 2 used most commonly as far as cited, and that's the fighting, engaging in a fight or brawl, which occurs quite a bit downtown. That's where that one's most commonly cited, and then also loud party, which with students coming back, we'll probably see a little uptick in that. Those are complaint-driven. Officers go out when neighbors complain that something's just absolutely unruly, but those are our 2 most common disorderly conduct type charges. We also have criminal trespass quite a bit. Basically, someone usually from prior criminal behavior has been told not to come back to a particular private, usually private property, but it could also be a park. But basically, usually let's say for instance, they've shoplifted from Hagen's in the past. Hagen says, we don't want you to come back here. The person goes back to the store or comes back onto the property. That's a common example of one of those. Theft and shoplifting are very, very common. Malicious mischief, which sounds more interesting than it is. It's basically breaking someone else's property. So, right, someone comes over to your house and purposely starts destroying your stuff, breaking out windows, things like that. And then a lot of the domestic violence crimes. So anything that I've listed, trespass, malicious mischief, assault, all of those things could also be domestic violence, which is a designation of one family or household member committing those crimes against another, okay? So one the other crime that I want to talk about and kind of show you how it can run sort of the spectrum is driving with a suspended license. And certainly there are very de minimis driving with a suspended license, right? You get your license suspended, first of all, by a volitional act by the defendant, right? They've done something. It doesn't just happen to them. And it can be something as de minimis as they didn't pay some fines. And that's still important to pay traffic fines and pay your speeding tickets, but that happens and then their license can get suspended. And we certainly treat those accordingly, understanding that those are, on that spectrum, much more de minimis type of violations. But when you hear someone say, oh, well, those are all driving license suspended charges, those people shouldn't face a severe penalty or they shouldn't be in jail. Remember that category in the opposite end of the spectrum is that we have driving license suspended cases where the people have had their license suspended possibly for years, 7 years or more, because they've killed someone in a car accident, they've committed a vehicular assault or vehicular homicide, or they've committed a first offense DUI or multiple DUIs. And so I'm not looking at that case and saying, oh, well, it's just a driving suspended license. This person should, this is not a big deal. My point to that is, on that spectrum, every case has to be looked at individually, and we have to say, is this where the background of this case, and looking at that background, looking at the reasons why there's a suspension, looking at the severity of that suspension, and saying, is this a public safety and community safety issue because this person has actually committed a very serious crime while driving a car and is now continuing to drive unsafely without insurance, maybe without an ignition interlock device, which would prevent them from driving while intoxicated. Maybe they're continuing to do that over and over and over again. And that's obviously going to be at that end of the spectrum where that's very serious. At the other end of the spectrum is, okay, somebody just got their license suspended for not paying traffic tickets, right? And the reason I say that is it's easy for someone to say, oh, well, it's driving a suspended license. There's more to it, right? You have to scratch the surface, right? You have to really get back and say, okay, well, what does that mean? What does that look like? Why is it suspended? What are the aggravating or mitigating factors that really make up this particular individual's crime? And so it's just much more complex than simply saying, well, that's an assault or that's a driving suspended. There's always more to it, right? And so that's kind of one of the things I want you to think about as we talk about specific crimes. That there's categories of crimes, but there's still a spectrum even within those categories, right? The other thing that I like to say when I think about kind of the crimes that we deal with, and I get it. I mean, I know they're misdemeanors, and a lot of people say, well, the jail should be reserved for people who commit felonies. Misdemeanors should be out. But as I've said, there certainly is a spectrum, and I would contend to you that the person who's on their 4th offense DUI is probably much more a public safety concern than the person who just, happens to have some possession of stolen property, but it ends up being of a dollar value that makes it a felony. From a community safety standpoint, the person who's on their 4th or 5th DUI probably presents a much more serious safety concern for us. But again, just showing that spectrum. But really what we get down to with our misdemeanors are, I like to say, these are quality of life crimes, right? When you talk to the members of the public, when I talk to members of the public, the yardstick they use to decide whether Bellingham's moving in the right direction, the wrong direction, and I'm not making any judgments one way or the other, just what you hear. Well, we're seeing an uptick in crime, or I'm tired of seeing X, Y, and Z, or Bellingham's getting more dangerous or is less safe. they're talking about misdemeanor crimes because those are the ones that they see, in my opinion and in my experience. They're seeing the urinating or defecating in public. They're seeing the constant fights downtown, which are currently on the uptick. They're seeing or reading about the assaults of random citizens downtown. They're seeing, you know, the multiple DUI arrests or things like that. I feel like that's, you know, the loud parties and all that the other crimes I've listed, even if those are more minor in nature, that's what they use as the yardstick to say Bellingham's moving in the right direction, Bellingham's not. It's safe, it's not safe, however they inform that decision. Right or wrong, too. I know those are impressions that people have, but I do feel like that's what I hear a lot. The average manslaughter case that occurs, you know, in Superior Court doesn't really affect someone's view. No one's seeing that. If someone commits a burglary at Hagen's at 3 in the morning, you know, people might read about it, but most people actually don't know about it. It doesn't, and I'm not saying it's not important, but I do think that these crimes are the quality of life crimes that people see that affects them, and as Peter said, they're going to be more involved, likely to be involved with, and that's going to be their yardstick for how Bellingham is doing, basically. I don't know. That's the way I look at it anyway. So let's talk about how do we handle cases. Well,
Don't sound so excited.
yeah, no, it's like teaching class. I'm teaching you guys how we do our job.
You are teaching us, yes.
But I just wanted you to think in those terms, I guess. So what I was talking about is a couple things that are kind of really big idea sort of things, and I want to talk about some real, I don't want to say too specific, but specific enough that you can understand sort of how we apply the things I just talked about to what we're doing. So when we receive a criminal case from the police have made an arrest, and they're handing us over basically everything that they've just compiled in their investigations. We obviously take that and we prosecute it to completion. Completion might be trial, and trial, everyone has to understand that the very end, if the defendant says no to everything, and if we're at a standstill, the end is trial. And trial is literally like what you think it is, which is witnesses go up and testify, people are sworn in, a jury of their peers is selected and decides guilt or innocence. That's exactly what it is, and that is the completion of the case. We don't often do that, but that is one pathway that a case can take. We might also dismiss the case for various reasons. Some of it might be that they've completed some terms and we've agreed that we're going to dismiss this case because you've completed X, Y, and Z terms. We might also just dismiss because, frankly, the victim doesn't want to pursue it anymore, or because we just can't prove the case, or we just don't think it's a very good case. Right? There's a lot of different reasons. The overwhelming number of our cases that resolve because of negotiation, right? We're negotiating. So when I say earlier, relating back to my point that I don't decide what happens ultimately, I don't make the decision for the defendant. What I do is I incentivize certain options, right? Okay, you're looking at this penalty, but if you agree to do this, we'll lower your penalty to this, right? It's a negotiation. We're trying to avoid the unknowns and uncertainties of trial, while at the same time trying to reach some sort of, stated goal, which is hopefully, if in certain cases maybe it's treatment that's necessary, or maybe it is jail time, or maybe it's whatever. You're looking at negotiating while at the same time balancing what does the victim want and do I have a good case, right? And so a lot of our cases, I would say the vast majority are negotiated and settled in that way. And what we're looking for, the big overriding theme there, is we're looking at mitigating circumstances and aggravating circumstances, right? Every case, I cannot stress this enough, every case is an individual decision. People are not widgets. Everything is not a good fit for everybody, right? So we often hear, well, mental health court would be a great option for people who have mental illness, and that is true. But of the category of people who have mental illness, the professionals will tell you that there's an even smaller category of people that mental health court is a good fit for. People with antisocial behaviors, just by way of example, or people, basically antisocial behaviors, I'll just leave it at that, aren't necessarily a good fit for that group dynamic, because sometimes they end up preying on or actually damaging the group. And so while the group is trying to heal and recover, some people aren't a really good fit for that model, right? So again, it's very specific to the individual, to the case they have, to that individual's personality, that individual's background, their history, and all of these cases that we decide are all based on the individualized sort of analysis of their case. And so when I do get a case, what I'm looking at are three main things. First of all, I get the charging document, which is basically tells me what they're charged with, right? The allegations. It'll say assault in the 4th degree, and then it'll tell us where and when this is alleged to have occurred. Probably the least of an important thing out of the three things we're looking at, but it's still important. The second thing are police reports. We're looking at police reports in combination with all of the supplemental things, which is photographs and victim statements, all that sort of stuff. The third thing is their criminal history. And the criminal history will include a lot of things. It certainly includes the history of the crimes that they've been either charged with, convicted of, but it also tells me a lot more. It tells me the charges that were dismissed. It tells me whether they've appeared for court. It'll tell me what their warrant history looks like. So how many times did they not show up for court dates, and what cases did they not show up in? And so we get a good picture of the track record of this person, from the crimes and the years and what's been happening, and not only just in their criminal behavior, but also their ability to and desire to show up to court. So those three elements then factor into us making basically an initial offer. So before we ever even go to court, we already are making an offer. Now, I understand you might say, well, you don't know, other than what you see on the paper and the histories, you don't know that person. And that's fine, but and I get that, and that's why that's the defense attorney's job, right? We come out and say, here's your initial offer. And I think this is important because at arraignment, we're telling every single defendant, whether they're in custody or out, here's what the city is willing to offer you to resolve today. A lot of those are real easy resolutions, knock down to infractions, do some community service, get it dismissed, things like that. The more complex cases, you're basically telling them, here's what we're looking at. If you do nothing to better your situation, we're going to recommend treatment or this or that. And then that gives the defendant time, if they want to plead not guilty, to work with that defense attorney to then present us the mitigating information over the course and the life of that case. So when someone pleads not guilty, I'll give you a good example. They're going to say, wow, the prosecutors wanted me to do 5 days in jail and probation and this on this assault case. How about, I know I've got a drinking problem. Now, they're not telling me this. They're telling the defense attorney. What if I go out and get an evaluation? What if I go to inpatient treatment? What if I do some community service hours on top of that and start mitigating that penalty down by showing that I want to improve myself or I want to do this better? That is what we do while a case is pending. Now, certainly we negotiate, and certainly a lot of times it's just analyzing whether you have a good case or not, but the vast majority of that time negotiating, that pretrial, what we call the pretrial phase, is spent with attorneys essentially exchanging information, and really we're at that point as prosecutors just getting in information from the defense attorney saying, my client actually has proof that they went to inpatient treatment and did 30 days. What can we do with that information to mitigate this penalty for my client to keep them on the right track? That's what we're doing.
Okay, you took a breath,
Certainly.
so I think I can interrupt.
No, yeah.
You're like the only person that I think talks as fast as I do,
Yeah.
so it's really nice to watch.
Well, I got 20 minutes.
I know. I think you said an important thing, which is arraignment. And so
Yeah.
we're coming from lay people not understanding
Sure.
this process, never been involved in it. And that's the confusing part. So
Sure.
somebody's been arrested. The police at that moment have determined that it's important enough that
Probable cause,
at this
right.
point they're in jail currently.
Well, yeah, or cited by summons. Either way.
Custody.
Either way.
Okay. And then when does arraignment happen? What is
Well,
that word
arraignment.
arraignment
So
mean?
the arraignment happens in every case, whether you're in custody or out of custody. That's
Okay.
your first time to basically hear the formal charges against you and to enter a plea of guilty or not guilty.
Okay.
And I'm saying is by that point, whether it's in custody or out of custody, we come with a plea offer in hand to at least let them know what their starting point is, right? At least I think most defense attorneys would tell you that's, first of all, it's not unheard of, but it's pretty rare, but it's also very preferable, right? Because they can at least go and say, okay, this is what you're looking at. You need to do some things to make that better. We don't wait months and months and months to tell them what they're looking at as far as a penalty. That doesn't mean it can't get better than that, right? It definitely can get better than that. But we at least come to that arraignment where they're formally entering a plea of guilty or not guilty. We're not expecting them to necessarily plead guilty, but we at least want to give them the opportunity to say, this is what you're looking at. You might need time to process that or time to think about what you can do to mitigate that, but we're coming to that initial appearance, with that offer. Now, at arraignment in custody, there's different rules. There's court rules for all this. Trust
You
me,
can keep
there's
it real
rules
simple,
for all
but
this.
that's just- I think
48
people
hours
need
if
to
you're in
know that,
custody, 2 weeks, basically, if you're out
You're
of
not in
custody.
custody. Okay.
So, for arraignment. So,
Oh.
and that court will probably cover some of that.
He'll cover it. Deb
Yeah.
will cover it a little bit. All right, thank you.
So if the person pleads not guilty, like I said, we're kind of going, I'll kind of wrap some of this up. We're basically giving ourselves time to really negotiate the case, right? Looking at maybe there's some mental health issues that the defense attorney needs to explore with their client. And one of my favorite lines the defense attorney ever told me one time is, we're going to resolve this case, but just not today. Today's not the day. And the reason they say that is the defendant makes that decision, right? The defense attorney doesn't make that decision. I could give them the best deal in the world, and they might even tell me, it's a great deal. But they're not going to take it, right? Because they make that decision. And sometimes, that's why I say with that offer, that initial offer, they need time to process and go, okay, I really need to think about, the pros and cons of taking this offer or negotiating the settlement or trying to do some probation, and mitigating and evaluations and treatment. It takes time. We're human beings, right? That's why I say we're not widgets. Everybody works on their own timeline, and we try to be very flexible and adaptive with defendants and individuals when they need some time to sort of, decide whether this is the path they want to choose to resolving their case or not. The other theme I want to get that I kind of want to wrap up with that, and before I talked about quickly the other scenarios, I know I'm running out of time here, is none of this works really without the defendant appearing. So when I say it's a two-part process, right? When I say the defendant chooses the path, and I can incentivize certain options, right? But it doesn't work if they don't show. If they don't come to court, I can't hook them into the systems, right? I can't offer them this, this plan. I can't offer a mental health court if they don't show up for the screening. I can't offer them, this treatment option if they don't come to court and know that that's an option. And so it really does require the defendants to be there, which is one of our great challenges and hurdles at times. But none of this works in a vacuum where I just sit with a defense attorney and say, yeah, what person A really needs is this. But if person A doesn't show up to court, at the very minimal, just show up. None of the rest of the things we do works. Court can't order them to probation if they're not there. If they don't show up to probation to be, at least monitored by a probation officer, they don't show up to FDS to get the ankle bracelets on, none of the rest of it that we're trying to achieve works. So it really is sort of incumbent when you review this process, because it's easy to say, well, why don't you guys just order them to do these things? Or why don't you just make them do this? They're human beings. They have free will. Yes, the court orders them to do certain things, but, just like the citation orders them to show up to court, they just sometimes don't follow through. And so that's one of the challenges that we obviously face. Did you have a question, Ms. Vargas?
I did. I'm just anecdotally,
Yeah.
How often do people not show up?
Oh, geez. The court probably has numbers on that. I don't want to speak too specifically other than, out of custody, I'd say at a arraignment calendar is probably 50 to 60%. I mean, probably 50-50, whether people show or not. So I know I'm probably running out of time, and I thought that I timed myself twice doing this, and I actually did go into 20 minutes.
Take the time that you need.
So I'm a little frustrated that as fast as I'm speaking, I'm also
It's
not.
like the Micro Machines guy.
So
I love
Lieutenant
it.
Ulmer talked about three scenarios when he was here a couple weeks ago. The first two are quickly get through, and then we'll talk more about the third one, which really does pertain to my office. He talked about protective custody. Really, that has nothing to do with my office, so I really don't have any information as to that. The second scenario he talked about was civil infractions, which we do deal with in my office by basically, infractions were fines only. There's no threat of jail time or anything like that with an infraction. It's speeding tickets. If you've got a public noise disturbance, code enforcement, not getting the right permits. And we do resolve those through hearings. Sometimes officers have to appear, but those are kind of a totally different sort. The one thing I will only say about that is no one ever goes to jail for those cases, and that includes not paying your fines in those cases. You do not ever go to jail for a civil infraction, nor will you ever go to jail for not paying a fine on a civil infraction. Frankly, you'll never go to jail in our court for not paying a criminal fine either, but you will never go to jail for not paying your civil infraction. The third thing that Officer Ulmer talked about was criminal cases, and really talked about, and you brought it up a little bit, whether the person's in jail or out of jail, whether they're in custody or not, when we do that first appearance, that first arraignment, when we see them. In custody, what we're talking about when a person's booked, the first thing we're obviously looking at is bail appropriate. And really, that goes into what I talked about earlier about the things we're getting. We're looking at their criminal history. We're looking at their failures to appear. Have they FTA'd? Means failure to appear. On this case, how long? For instance, this morning I did the jail calendar. One person hadn't shown up for over a year. Just wasn't going to show up. Another person was in there on 7 cases she let go to warrants. She wasn't going to show up for any of them. And they ranged from trespass to assault. Wasn't going to show up. Hadn't shown up. 7 cases pending. Multiple citations, multiple times to show up to court. 7 times. Blew them all off, right? So that's the person we see in court today, and you have to make a determination, and the court does, and there are very specific court rules about this. CRRLJ 3.2 discusses the factors of which a court must weigh, and the attorneys essentially argue whether bail is appropriate under those factors. And those factors include things like criminal history, their likelihood of appearance for the future. Someone who hasn't shown for 7 cases in the last month and a half, not likely to appear in the future. So those things factor in. And public safety risk factors, right? So doesn't necessarily have to have an extensive history, but if you have a very, very serious domestic violence issue or a violation of a no contact order, right? We have people who get out of jail for a domestic violence issue the very next day, frankly, even that afternoon, go right back, right, to essentially violating the no contact order. Those are public safety risks, right? And so those bail and other things might have to be put in place. And we look at FDS, which is our new screening tool, which we've been using. And so we look at all of that, and the court has to weigh all that out under the court rules and decide whether bail is appropriate. I would say the most common type, like this morning, it's mostly warrants. I mean, we do have some mandatory bookings, which are DUIs and domestic violence, but really those are so we can get some structure in place, right? A domestic violence, you don't want to just say, well, show up to court in 2 weeks and hopefully you don't terrorize, the victim in the next 2 weeks, right? You want to get them into court because you want to get a no contact order in place. You want to talk about what's appropriate. You want to look at, should this person be on monitoring, things like that. Same with DUIs. But the only other cases that we really have in custody most of the time are going to be, not most of the time, the rest of them are warrants. People who just have chronically or just not shown up for court. That doesn't mean they're going to stay in custody, because we're going to run through all those mitigating and aggravating factors to see, what we can do with their case. But that is how people end up there, the vast majority. And the examples that I gave you from this morning is, I thought the one was from this morning. I was like, oh, she just picked this up on 9/22. I was like, oh, of 2016. She just hadn't shown up for a year, just blew it all off. And then the other person was 7. That's common. And it's unfortunate that it's common, but that is common. So when we're looking at those cases now, those people remain in custody. Now we're looking at all those things. Do some of them have treatment? Or do they have substance abuse issues? Is there some treatment we can start offering? Is there some way that we can solve this person's, the issues? Is there housing issues, that we can maybe start looking at through the different programs? That's again, all those things that we want to plug them into can't do anything until they're there and in front of us. And it's unfortunate, but that's really the way it works, right? So that's what happens if we're, in custody. We're really looking at bail. If they're out of custody, it's really, as I said, they're doing the same process as far as entering a plea of guilty or not guilty, and then essentially we're going through the pretrial phase, which I discussed earlier, and really looking at the individual's case and really diving deep into that individual's issues, right? Okay, do they have substance abuse issues? Do they have, mental health issues? Is this a one-off case or a DUI where we're not going to see this person probably again, or a shoplifting case where it's a college student who just, decided to shoplift that one time and they're really embarrassed and they'll never see him again. Okay, what can we do to mitigate the consequences for these individuals, right? Because that's what it ends up being. And I like to think of it this way: is you can do this job with compassion, and you can do it very, very, I don't want to say angrily, but you can do it very hardline, right? I prefer to do it with compassion. Remember that each of these people, while I might have 30 of files on my desk, and I try to get all my attorneys to remember this is every time that case gets called, that person's nervous as heck that their case got called, right? We're just, going through the files, but we have to remember that this is their individual life. These are the choices they've made. These are the consequences they're going to face, and we should take that just as seriously as hopefully they're taking court. And we have to remember that every time we're getting these cases. And I say that because the mindset has to be, this is an individual's life, this is an individual's record, and we need to be making very smart, savvy decisions with as much information as we can. Now, that doesn't mean that we're going to dismiss everyone's case and always necessarily agree on the resolution. But we have to be smart about the way that we do this, and we have to do so, I think, with at least some level of empathy and compassion, instead of just saying, well, we want convictions, or we just want to, take a hard line all the time. In summary, so I'll finish up, a few of the things that I hope you get from what I'm saying are that, every case is looked at and treated on a case-by-case basis. There's no one-size-fits-all approach, and what we're really looking at is, what are the tools in our tool belt? And I would ask you that we're always looking for new tools in that tool belt. But there's not one tool that fixes every individual's problem, and there's not necessarily, again, I'll go back to the example of mental health court. That isn't just a cure-all for everyone with mental health issues, because there's an entire category of people dealing with mental health issues who that's not a good fit for. And I'm not saying that as an attorney. I'm saying the professionals, the mental health professionals, are saying that, right? So you look at them on an individual basis, and a case-by-case basis, but you also have to remember that, or you also have to be looking at what tools do we have, what tools do we need, and how do we access those in trying to sort of solve these problems. Because as Peter said in the beginning, we are a court of rehabilitation. So yes, we do have punitive measures. Yes, we do have accountability measures, and I absolutely think there is a time and a place to use those, and we do. And I think they have value. They're not always there to serve as a rehabilitative measure, but sometimes jail time is appropriate as a punishment. But we also have to, temper that with an aspect of rehabilitation and looking at how do we make this situation not occur again, or how do we make this person, better? How do we lead them on that path? But that leads me to my second theme, which is nothing the court offers and nothing that I can make available or the court makes available works if the defendant isn't engaged. It just doesn't. If they fail to show up for court, if they fail to show up for those screenings, they fail to show up for arraignments. I mean, what am I supposed to do? If somebody fails to show up for their theft case for arraignment, let's say like this person in custody today, she doesn't show up for a year. Should I just dismiss the case? That's not fair, in my opinion. That's not fair to all the other people who go, I got a shoplifting ticket, I'm going to show up for court, and I'm going to show up for my arraignment. So they have to deal with their case, but I should dismiss the person who doesn't want to show up for the next year or two? It's not fair. We have to treat people equally in that respect, while also respecting their individuals. But I'm also not going to simply dismiss somebody's case because they don't show up for court. It's not fair to the other people who do show up and now have this on their record or are taking responsibility. So my point to that is none of the things and none of the tools we have work unless the defendant is engaged. And sometimes it's unfortunate, but they only end up being engaged once you force them, which is when they're in custody. And even then, they don't want to be engaged. And that's my other theme, which is the defendant ultimately makes those decisions on whether to resolve the case or take certain paths. They're the ones that make the decision to plead guilty, take probation, believe in probation and work with probation and do what they should be doing on probation, going to mental health court, going to treatment. They make those decisions. Again, I can incentivize those pathways for them and hope that they plug in. Classic, lead the horse to water, but you can't make them drink. But they ultimately have to make those decisions, say, I'm ready to engage and do that. And that's tough. I mean, I'll be honest with you, that can be very, very, very difficult.
Well, thank you. Are you able to stay? I know Judge Lev,
Yeah.
you were going to maybe present some things, and if the committee wouldn't mind, we could maybe hear what Judge has to say. I know we all have some questions, but
Sure.
she might satisfy some of those
Yeah,
questions,
absolutely.
and then we can open it up for some dialogue.
Sure.
Thank you for your
Yeah.
presentation. Welcome back.
I should know that from last time. Thank you for inviting us. I'm Deborah Lev, Municipal Court Judge. Darlene Peterson, Court Administrator, is here as well. And thank you for your interest in Bellingham Municipal Court operations. Picture this. You've just been charged with a crime within the city limits of Bellingham. If you are in jail, you will be before a judge within 48 hours. If you are out of custody, you must go to court to your court date or face a warrant for your arrest. So I'm asking you to sit back and please listen carefully as we journey through the beginning of your experience in the criminal justice system. Whether it be your first time or the 20th time that you're in criminal court, this is likely what you will hear. Good afternoon. We're on the record. This is Bellingham Municipal Court. This is September 25th, 2017. For those of you that are here for arraignment, I'm going to go through your rights at this time. This is the time that you're informed of the charge or charges against you, the rights that you have in defense of the charge, and the consequences of entering a plea, after which you'll get the opportunity to plead guilty or not guilty. By entering and maintaining a plea of not guilty, you preserve all the rights you have in defense of the charge. If you plead guilty, you give up your rights, you're sentenced here today, and the matter is final. If you plead not guilty, you have the right to have a trial within the next 90 days, 60 days if you're in custody. Your trial will be scheduled as a jury trial unless you give up your right to a jury and have your case heard by a judge sitting without a jury. You're entitled to be represented by an attorney of your own choosing at your own expense. If you cannot afford an attorney, one may be appointed for you at public expense if you meet the proper financial criteria. You may waive or give up your right to an attorney here at arraignment or at a later time if you wish. At trial, you may hear and question the witnesses against you, call witnesses in your own behalf, and compel them to be present at no expense to you if they will not come voluntarily. You may testify at trial or not, whichever you elect to do. You are presumed innocent unless proven guilty beyond a reasonable doubt, and if found guilty at trial, you have the right to appeal to Superior Court. If you plead guilty, give up these rights, you're sentenced based upon the facts contained in the police report, and there's no appeal of the sentence. The maximum sentence you can receive for any one offense in this court is 364 days in jail and/or a fine of $5,000. In addition to any jail time or fines, you may be placed on probation. You'll be required to pay a monthly probation fee to supervise you for each month that you remain on probation. You may also be required to undergo an evaluation for whatever problem may have contributed to the commission of the crime, and as a condition of successfully completing probation, you must follow the evaluator's recommended program. If there's been a victim of the crime who has suffered personal injuries or property damage or destruction, you will be required to repay that victim by way of restitution. For certain driving offenses, your license or privilege to drive in this state may be suspended or revoked for a period of time. There are certain offenses that carry mandatory minimum penalties that a judge cannot suspend. If your case falls into one of these categories, I will advise you of that before taking your plea. If you're a citizen of a foreign country, some offenses can make you an excludable alien or prevent you from naturalizing as a U.S. citizen. If you are a citizen of a foreign country, you may wish to plead not guilty at this stage and consult further with an attorney. So when you hear your name called, please come forward, have a seat at the table where there is a microphone situated. And we are taping these proceedings, so please speak out loud in response to my questions. If you want to be considered for assigned counsel, that's a public defender, an attorney who's appointed to assist you with your case, please let me know that if I don't ask you about it first. You will need to apply for an attorney. Madam Clerk in the courtroom will give you an application. You just need to take it downstairs, complete it, and turn it in at the clerk's window before you leave the building. It is a sworn financial statement, a short form regarding your financial circumstances. We go by the federal poverty guidelines. If you're eligible, you'll be handed a business card with your attorney information on it and another sheet of paper that instructs you to go straight from the courthouse directly over to your attorney's office, which is just across our parking lot, about a block from here. If you don't get a business card, you may still be eligible. We just need more information back from you. You'll get a different sheet of paper that tells you what information we need. Please turn that documentation into the clerk at the lobby window as quickly as possible to get an attorney on board. Also, for your information, we do have attorneys here from the Office of Assigned Counsel, and then I describe where they are and identify them. If you would like to have an attorney right here this morning for your arraignment, that's your entry of plea and release conditions, and you haven't yet spoken to one of these attorneys, please feel free to approach one, ask for their help, because that's why they're here. Thank you. So that gives you an idea of what happens at an arraignment. That's what I say many, many times in my career. But it's all very, very important information for someone who is experiencing a criminal charge, which can be devastating, or for someone who's there, as a frequent flyer, it's still very important information. I call each person up after rights. I ask, did you understand your rights? Do you have any questions at all about your rights? And then, generally speaking, most people have an attorney. There's a few that don't, constitutionalists generally don't want to have an attorney. But I encourage them to have an attorney right there at arraignment. And by the way, that's a City of Bellingham Municipal Court, kind of exclusive for having attorneys at every single criminal arraignment, in custody and out of custody. They have the right to have, and we have attorneys present for them. So also we have interpreters, just so you know, in case someone doesn't have English as their first language and is not comfortable speaking, especially at a complicated hearing. We have interpreters. We don't always have them the first arraignment, so we have to continue to bring an interpreter back. We do have some court staff that speaks certain languages fluently, and we can get enough information to those who don't even understand about signing a promise to come back. So I want to tell you about our local rule number 2, which requires a mandatory appearance for certain charges. And in your packet, you have the criminal offenses, misdemeanors and gross misdemeanors. That's the distinction. Felonies go up to Superior Court. And Sometimes we get a notice of appearance from attorneys that, not public defenders, because that happens at arraignment where they get hooked up with public defenders. But if a private criminal defense attorney files a notice of appearance on certain matters, the person doesn't have to come to arraignment. The plea is entered on their behalf and the process goes forward. There are certain offenses that can't happen. An attorney cannot file a notice of appearance and waive their presence of their client at arraignment. I'll give you the examples, or actually the specifics. Anyone who's charged with an offense of domestic violence, assault in the 4th degree, harassment, indecent exposure, violation of any court order, cyberstalking, cruelty to animals, negligent driving in the 1st degree, driving while under the influence or physical control, and those are the ones that they must appear personally. You can't have an attorney in your stead. So, any questions so far? I'm trying not to go too terribly fast.
You're doing great. Thank you.
Keep going. Okay. So that's when the person or their attorney, more likely, enters a not guilty plea. And we talk about bail and release conditions. They receive what's called the essential elements of the crime charge from Mr. Anderson's office. The attorney gives them, it identifies the charge, and we put on the record that they've received that because that's required by law. I review the law enforcement reports for probable cause, which means facts or circumstances that are sufficient to warrant a reasonable belief that a crime has been committed by that person before you. So I review for probable cause, and assuming there's probable cause, then the attorney enters the plea. If it's not guilty, then we go on to the next step, which is determining bail and release conditions and setting further dates. More than 50% of our defendants are assigned counsel, in case you're wondering. Everyone is screened in custody for assigned counsel. Everyone is given that opportunity out of custody to screen for assigned counsel. Then we talk about the pretrial release order. It is, as Mr. Anderson indicated, each case is analyzed case by case on its own, individual circumstances. Some of the things that I think about, just generally speaking, the present charge and allegations, defendant's criminal history. I have the screen right in front of me. I can see what this person has been charged with. I can see whether, as Mr. Anderson indicated, whether there's been failures to appear, whether there's active warrants in other jurisdictions. For goodness sake, we see so many people before us that have warrants in district court, some in Superior Court, Skagit, all down the corridor. I can see it in state. Safety concerns to the alleged victim and or public or the defendant, him or herself. I also, of course, take into consideration the prosecutor's recommendations. The victim advocate and alleged victim input, sometimes we have that, and the ties to our community, employment, that sort of thing. So all of that's taken into account to determine whether this person should be released on their personal recognizance, the conditions of release, whether bail should be ordered, whether that should be a bondable or whether it should be a cash performance bail or court-approved performance bond. And if you have questions about this jargon, let me know.
I have a quick question for
Yes.
you, Judge Lev. You said 50% are assigned counsel roundabout, and that means 50% of people are qualifying for that public
Yes.
defender. Okay, I just want to make that clear.
Indigent according to our federal poverty guidelines. And we do have them fill out the application. They have to provide verification for us to assign.
And so up to this point of arraignment, have you already been through the process of identifying if somebody could use friendship diversion, or is that after arraignment?
That's part of arraignment.
That's part of arraignment. Okay.
For pretrial release conditions to be on GPS or monitoring, alcohol, scram.
Thank you.
Pretrial supervision then is what that we're referring to. That's through the Whatcom County Probation Department, which I'll again plug as the best in the state, in my opinion. There's testing, there's surrender of weapons, there's surrender of license plates. They do have to report directly from court to probation, and we check on that. Scram, GPS, in-home monitoring, where they have the device at home and they're blown into it 6 times a day randomly. and when they're called, and ignition interlock device installed on their vehicles if they do have a license. So those are some of the things that we have as tools to ensure the safety of the community and the safety of any alleged victims. Then the next stage after those release conditions are ordered and they're on their way, well, actually before they're on their way, is to set their pretrial dates. And we do set a pretrial to try to avoid setting trials and then having to continue matters when the trials are set. So we have a pretrial stage, and then at pretrial we can set for trials. That can be either a jury trial or a bench trial. And I do, of course, invite any of you to come to court, some of you again, to see our proceedings. I think it's a really good way to see how your court functions, because you get what we've been talking about, the case by case. You know, two people can be charged with exactly the same thing, and it can have very different outcomes. Not as far as the consistency of sentences and such, but just because of what they have in their past and you know, what's before us. So it's kind of a good way to see an assortment. As far as failures to appear, if I had precise numbers, well, I might have them, but I don't have them with me. I can just tell you what I see. Friday, we had everyone appear but one person. Unusual, very unusual. I think we've had 1 or 2 times where everyone's appeared, and we celebrate. Today, I had half the people fail to appear. So, and arraignments can go anywhere from 15 people up to 50 people. We're going to have plenty of parties and MIP charges, I think, coming along not too far in the distant future if history repeats itself.
So if somebody doesn't show up to arraignment, is then automatically a warrant placed out?
I
for their
review the
arrest?
police report for probable cause, and if there's probable cause, excuse me, I have authority to issue a bench warrant.
And what are the options for somebody that they forgot, something
I'm
happened?
glad you bring that up. As far as warrants go, I think we bend over backwards as much as we can to accommodate people who have warrants. So, and we consider the jail overcrowding and everything, of course, but primarily I consider the safety to the community and the respect for a criminal justice system, so it makes sense. But if you do have a warrant because you failed to appear in court, all you need to do is contact the court and schedule what we call a quash warrant hearing. So it's quash, not squash.
Okay.
But in any case, a quash warrant hearing takes no fee to set. You come in for free. You surrender yourself on the warrant. And I don't think, you know, most of the people that come in on surrenders don't go to jail. They're there, sometimes very quickly, sometimes with reasonable excuses for why they missed, and sometimes, you know, they haven't had notice. So we quash the bench warrant. There, in some cases, are warrant costs assessed. Generally, they don't have to pay that right away. Many times, they don't have to pay it at all. But they come in and they quash their warrant, and then they're back on the track for arraignment and everything I've told you about. It is so easy to quash your warrant in Bellingham Municipal Court. That's not to say that we haven't had people taken from court to the jail, because we have to for safety considerations if they can't post a bail. But really, the process for quashing is relatively simple, and we do that every day but Monday morning, I think is what we decided, because Mondays are sometimes very busy from the weekend. Every day, let's see. No, I guess they can quash on Mondays, right? Or is it just Thursdays and Fridays?
So it's readily available.
Anyways, it's readily available on arraignment calendars. They just follow arraignments,
Okay.
and then they quash.
Pinky.
I have a
Anita.
quick question about how we let people know when their arraignment is. Do we call them, send them letters? How does that process work?
Well, they're arrested by law enforcement, and then they're given, if they're released on scene, they're given their citation with the court date. So if they're out of custody, that's how that goes. And our court gives a courtesy call to remind people of their court dates the day before. If it's Monday, it's on a Friday that we call. So I've had people in court say, well, the court didn't call me. That's why I forgot my court date. I'm like, well, the court isn't required to call you. They just know from prior experience being in court that we do call. Well, in fact, we did call, but the phone wasn't working, or whatever the case is. But we're not required to do that. We do that as a courtesy. So that's how they know about it. Some are sent summons, which Mr. Anderson does the complaint, and it's forwarded from the court with an order to appear in court on a specific date. And we have rules we have to follow for the timing as far as notice goes. So they can come in by summons as well.
I think it would be helpful to have more information on that. It sounds like a large number. I know it's anecdotal, but 50% of people not showing up, which creates a whole nother set of issues. And then we have warrants out, and then that can clog up the police and all of those things. So it'd be very interesting. And Darlene, I don't know if you can get the information, but are there themes, particularly mental illness, substance abuse, homelessness, that we're seeing reoccurring over and over in that group, or is it pretty random? And is that information even easy to get a hold of?
I would say it's pretty random.
Okay.
It's every group, but I will certainly look into that and see what I can do to see if I can find any statistics for you.
Okay.
We do have a warrant wall.
Yeah, yeah.
So we have thousands of outstanding warrants at this point. But keep in mind, too, if law enforcement has contact with someone who has a warrant and they have mental health, or they're transient, or there's some other issues, they can have them sign a promise to appear. And we do have some of them appear in court that way. They just have that reminder from law enforcement. But, you know, we don't want to be necessarily clogging up the jails with people who just can't get it together to come to court.
I think the other information I would find really valuable is, are there themes as to the types of criminal offenses that are being seen and not showing up? So like sleeping and lying. I don't even know if open container would go that far, but are we seeing themes to where our ordinances, I'm very interested in, are our ordinances doing what they're supposed to do? Because they're not just there to upset people or fine people or criminalize people. They're there to hopefully change that behavior because it's a nuisance or a criminal nuisance. So,
Well, you have to remember that sitting and lying, those are infractions.
Infractions,
So
okay.
there's no jail associated with it unless it rose to the level where it finally became a criminal offense.
Okay.
So there wouldn't be a warrant going out. They would get a fine and they would owe that fine, but they wouldn't be subject to being arrested unless it came to multiple
it'd have to be
offenses.
something
Right.
multiple to that.
And I know that Mr. Anderson made this point several times, but I just want to reiterate, no one goes to jail in Bellingham for failure to pay a fine. No one does.
Just-
So I know there may be other jurisdictions.
Just to clarify, so open container is always an infraction. There is no way it ever becomes a criminal charge. Sitting or lying, you get a warning, then 2 infractions, then if you have contact, the officer can cite for a criminal charge directly. But it's a build-up process. Basically, it's your
So,
fourth
yeah,
time.
I think as you're looking at that information to see if there's themes on those common issues that we hear that people are concerned of it being criminalized, mental illness, substance abuse, homelessness. But then are there offenses that we're seeing real regular that tend to be more people are not showing up for whatever that crime is? It would just be interesting to see. And then I think because we have little control. I mean, we can help with budget. We can satisfy maybe if you come to us and ask us for particulars. But we do set ordinances, and those ordinances sometimes are maybe causing somebody to be in front of you. And I want to make sure that they're doing what they're supposed to be doing and not just keeping our police extremely busy and the courts extremely busy. So if you saw any themes, I'd appreciate that. Pinky?
I'm interested in that information, but also what are the barriers for people not showing up? I'm kind of curious of that. Is like, did they not have transportation? Did they not have childcare? Like 50% of people not showing up. I mean, that's a lot of things that cause way more things down the road for our judicial system, for our police, et cetera. So it would be curious to see if there's some things that we could solve in those barriers, if that's what it is, or if it's just they don't care. I mean, there could be lots in that.
Okay, we're getting closer. Any other committee members or Michael?
Well, I really appreciate, Ryan, you're talking about just proportionate and individualized case-by-case response, and I really liked you saying that nobody goes to court for fines, and Judge Lev, you said the same thing. Yet I've been told, no, it does happen. I'm trying to figure out what must the circumstances be. Do we ever issue any kind of warrant for failure to pay a fine? What possibility might there be, whether it be snowballing, that leads to the sort of anecdote that I've heard, which really disturbs me, that someone who is sort of in a sub-criminal behavior ends up in the system fully criminalized? Do I believe the anecdote, or how can that happen?
There is, I have
doesn't
never
happen.
sent, I can't even think of can you think of
No,
any
there's-
case? There's no such thing
Never.
as a person
Not in
going.
Bellingham Municipal Court.
Not in Bellingham Uni.
People confuse courts sometimes. I know some of the smaller jurisdictions, I think they've stopped that practice, but they used to years ago. Linden and others
Municipalities.
did do
they
that.
have.
I've been here 11 and a half years. That's never been a practice of our
Is there
court.
a
So
way
it could be
that-
other courts, could be a combination of things, right? I mean, people are sometimes prone to exaggeration. Maybe it suspended their license, and maybe they're referring to, that they didn't pay a fine and they went out and got their license suspended and drove. I mean, it could be a lot of scenarios.
That would be a buildup that I could see if.
Right.
But.
And someone would say
that's a
that, but
criminal
that's not.
charge. Driving suspended third is a criminal charge. And we're very reluctant to even send people to jail for just the simple driving suspended third charges.
Okay.
It takes a lot to get to jail on
Yeah,
one of
sure.
those.
Oh, yeah.
And
So it's
Councilmember,
not us. We don't do it.
Councilmember Hamel?
Thanks to the chair for recognizing me. I'm not on this committee, but I did want to ask a question to the either to the prosecutor or judge. To what extent would a portability court be useful in our community, or would it not?
Would what?
A portability court where a judge or a commissioner could hear cases from different jurisdictions, would have the authority to do that via MOUs or some type of memorandum of agreement with different jurisdictions.
Well, I do that on Sunday. I mean, I already hear all the other courts on the Sunday hearings because of the rule that in custodies have to be heard within 48 hours. So we have a rotating system that way in place. So I wouldn't think that it would be difficult if you wanted to expand in some way.
And that would be pursuant to out-of-custody individuals, that expansion.
That, I guess, would that be, I mean,
I'm sorry, I'm just not familiar
we'd
with
have to
what it is. but
research
yeah.
it a little bit more, but I can hear I'm authorized to hear other courts' cases if necessary. Will it help? I don't know.
Are you trying to get at like somebody who's got court in different jurisdictions, if they were consolidated so they'd have one court hearing? Is that what you're trying to get,
Yeah.
what it's trying to get at?
That would be something that would help.
I mean, I'm
would
just trying to
think.
brainstorm, that's why that would.
I'm trying to see if there's another tool to add to
Yeah.
the tool belt in terms of FTAs.
Sure, no, I know, I'm just trying to see
specifically.
what problem it's trying to solve.
Yeah,
I
FTAs.
can tell you, yeah, exactly. I can tell you whether it's effective if I know what problem it's trying to solve. So that's what I was trying to think of. If that's what it's
Sure.
trying to get at, is if you've got court date over in district court and you got a court in Everson and you got 3 different court dates, if that's what it's trying to get at.
Yeah,
I'd
that's
have to
it.
think about it more, but I think, as Peter and I like to say, hey, all ideas are good ideas, and we can explore anything. Again, putting all the tools, in the tool belt, I think, are worth exploring.
Okay, we're just a little bit over. I will, just to let everybody know, I'm not aware. Brian, can you help me with, I think it's October 9th, what we're going to be doing? I know that we have October 23rd and November 6th all lined up.
Thank you.
Brett Heinrich, Mayor's Office. So on October 9th, we'll talk about system-wide uses of alternatives. So obviously include what Bellingham uses, but we want to take, I think, a snapshot of what's available via Whatcom County. Okay. And then we had originally discussed October 23rd to tie in the discussion of criminal justice impacts on the city's budget. There was some discussions earlier. We'll move that one to November 6th to accommodate the
Your report on the 23rd.
report. Thank you.
Okay. Well, thank you, everybody, for
Can I
coming.
just add?
Oh, yeah.
I stopped at the pretrial stage thinking that we'd get to guilty pleas and sentencing when it was appropriate for a later date.
Yeah.
And jail alternatives
Yeah,
and
that's
all
where
that.
I'm trying to kind
So
of line up.
That's
so-
why I stopped right
Okay,
there.
trial and sentencing. Yeah, I think that's helpful. And then I think within this,